Well, welcome everybody, and welcome to Greenway Chambers for another one of our CPD sessions. We put a bit of time into the selection of the topics for these things, and we try to make sure that they're relevant and topical and useful, not just a way of getting points. And this one ticks all of those boxes. Most of you, if you practice in commercial litigation, or any litigation for that matter, will from time to time come across circumstances where the enforcement of a written contract is affected by the conduct of the parties, whether that's an estoppel or a waiver, or in this case the modification, an oral modification of a written contract. Those types of circumstances arise in many circumstances in commercial litigation when people are trying to avoid the operation of the written contract. Tonight's session is quite topical. There's been some development in that area of the law, both here and overseas, and the presenters tonight will walk you through the details and help you come to grips with all of that area of the law. We've got two speakers. We're going to kick off shortly with Ashley Cameron. Ashley had a very impressive start to her career in the law. She started with a 12-month period as the tipstaff to His Honour Justice McDougall when His Honour was on the bench and in the equity division of the construction list, and so no doubt watched many of these issues play out in His Honour's court. She then began working at Trescox and later HWL Ebsworths as a solicitor in the litigation, both in insurance and commercial litigation areas. And then on coming to the bar, rather impressively, she was awarded the Katrina Dawson Award, which is given to the most outstanding female candidate who's about to start practice at the bar, and then won the Ludlows Award, which is given to the person who achieves the highest marks in the bar practice readers' exams. She makes the rest of us feel pretty inadequate, to be honest. Ashley's now got a busy commercial practice in construction, insurance and general commercial work. We'll then move on to Ben. Ben Jacobs has an interesting background. He didn't come to the bar and to law in the way that a lot of us did. He began as a chef in some of Sydney's better known restaurants, I think including Rockpool. So for those of you who can, it's probably worthwhile staying around for a nibble after the session. Ben Ben is a foundation member of Greenway Chambers. Prior to coming to the bar, he worked at Mallison's in the dispute resolution department, and for those of you who are about my vintage, that is new speak for litigation. He was involved in some substantial litigation while working for at Mallison's for the now Chief Judge in Equity, Justice Julie Ward. Like Ashley, Ben also worked in the courts, gaining some valuable experience as an associate. He was associate to Honour Justice Catherine Branson in the Federal Court, and then since coming to the bar, he has developed a very busy practice in commercial and construction litigation. So I'm going to ask Ashley to come to the lectern in a moment. We might leave the questions, if that suits everyone, to the end, and I'll throw the floor open for some questions dealing with those issues that arise on the papers. I take it you've all got a copy of the paper? Good. Okay, Ashley, you want to kick us off? Oops. Excuse me. Get that out of your way.
Thanks. Okay. All right, so just as a bit of a roadmap of what we'll be talking about this evening. So the first two topics I'll be dealing with, and then I'll hand over to Ben to talk about the last two. I'll be dealing with, firstly, the current Australian position in relation to no oral modification clauses in contracts. And then I'll have a look at the two Court of Appeal decisions that have been handed down this year since the decision overseas in Rock Advertising. I'll then hand over to Ben, who will talk about the Rock Advertising decision, and then also deal with the position in relation to where we go to next, and particularly in relation to construction contracts. Okay, so firstly dealing with the Australian position. So the current position in Australia is that notwithstanding any no oral modification clause in a contract, it's open to the parties to agree either by express oral agreement or by their conduct to enter into a new contract or to vary their earlier contract. So this means that no oral modification clauses in Australia currently aren't binding on the parties if they enter into a subsequent agreement or variation to their original contract. The principle has been confirmed in the High Court and also in a number of intermediate appellant decisions. Now, the principle in Australia is, and I've gone too far, the principle in Australia is based on the principle of freedom of contract, which basically provides that parties are entitled to strike whatever bargain they desire, and they're not limited in that regard by any earlier agreement they may have had. Some argue that this is counterintuitive because obviously if parties are entitled to strike whatever bargain they desire, then they should have been able to strike a bargain which required them to only vary that contract in certain ways. However, the position that the Australian courts have taken in that regard is that they give effect to the latter agreement, and the reason for that is that the courts have found that that's more likely to be reflective of the intention of the parties, and in addition to that, they infer that by entering into that latter agreement or the subsequent agreement, the parties intended to remove the requirement of the earlier agreement that certain variations be done in particular ways. That is the position in Australia, and it was the position in the United Kingdom prior to the most recent decision that Ben will deal with later. So there's three things that I do want to mention in relation to the Australian position which are relevant. So the first is that in entering into a new agreement or varying an earlier agreement, the new agreement has to itself satisfy the requirements of a concluded contract. So in other words, you have to have offer and acceptance, there has to be an objective intention of the parties to vary their earlier agreement or enter into a new agreement, and there must be consideration for that new agreement. So unless those elements are proved, irrespective of any no oral modification clauses, the new agreement wouldn't be given any effect. The courts have also said that the parties should have turned their minds to the topic of the variation. So in other words, if the parties haven't actually thought about the terms of their new variation or their new contract, then that won't be given effect to either. And the reason for that is that there's no clear intention on the part of the parties that would form their new agreement or their variation of contract. However, in Australia, the parties don't need to have turned their minds to the requirements in their original contract that any variation be done in writing or signed or any of those requirements. The courts have said that basically they infer that by entering into that latter agreement, the parties intended to waive those obligations that were set out in their earlier agreement under the no oral modifications clause. The second point that I should mention is that a no oral modification clause will still be relevant in determining what the parties intended by their latter agreement or their subsequent agreement. So in other words, the courts will still take into account the fact that the parties had a no oral modification clause in their first contract. And so that means that it will be more difficult for the court to infer that the parties intended to enter into a new contract where they had a previous agreement which required certain requirements for that contract to be effective. So even though a no oral modification clause won't be effective in precluding the parties from entering into a new agreement, it will be relevant in determining what the parties intended by their conduct in entering into that new agreement. Then finally, relevant to the position in Australia is that the law of equity still prevails. And that means that where a party has induced or encouraged another party to assume that the formal requirements of the first agreement no longer need to be complied with, or that a variation has been effective despite the fact that those requirements haven't been complied with, the courts will step in to prevent that party from later insisting upon the compliance with those requirements. Obviously, there's additional hurdles if a dispute of that nature goes to court, because you would need to prove that there's inducement and that there's reliance on that inducement. So in a litigious context, that's more difficult. However, provided those elements are there, the Court of Equity does step in to protect the innocent party, irrespective of the fact that a no oral modification clause won't preclude a latter agreement. Okay. So as Ben will talk about later, there's been a recent decision in the United Kingdom Supreme Court called Rock Advertising, which has signified a divergence in the position between the Australian position and the position in the United Kingdom. Since that decision was handed down, there have been two decisions of the New South Wales Court of Appeal which have referred to that decision, or referred to no oral modification clauses in New South Wales courts, I should say. The first decision is the decision of Bundanoon Sandstone. Now, the basic facts of that case were that a company, Cenric Group, who's the respondent in the appeal, entered into a head contract with a company known as TWT to excavate and harvest natural sandstone from TWT's development site in Piedmont. Cenric then engaged a subcontractor, Bundanoon, to perform the excavation and harvesting work, and under the subcontract, Bundanoon was entitled to proceeds from the sale of the sandstone, subject to certain royalties being paid to Cenric and to TWT. A dispute arose between the parties, as it always does in our lives, as to the payment of royalties and who should be entitled to them. The representatives of each of the three parties attended a meeting in February of 2018, at which they entered into a new agreement to to vary the contract and the subcontract to provide an extension of time and to increase the scope of the work. So instead of going down so many tiers of sandstone, they increase the scope of works to go further down, so there will be more sandstone. Now, after the meeting occurred and the agreement was reached, TWT issued a show cause notice to Cenric and took the works out of Cenric's hands. Bundanoon then terminated its subcontract with Cenric and entered into a contract directly with TWT, thereby avoiding the royalties it would have to pay to Cenric. Cenric then commenced proceedings, and it was successful in the first instance before Justice McDougall on the basis that its contract was terminated invalidly, and it argued that the new contract was, the variation that was entered into in February 2018 precluded the parties from terminating their contract in the way that they had. Ultimately, Cenric was awarded almost $4 million in relation to the loss it had suffered as a result of that wrongful termination of the contract. His Honour found that the parties had, looking at the context of the conversations that occurred at the meeting, that the parties had reached an agreement at the meeting to vary their earlier arrangements, and also that they intended to be immediately bound by that agreement, despite the fact that there was no oral modification clauses in both the head contract and the subcontract, and that was clear, His Honour said, from the conversations that were had at that meeting and his findings of fact as to what was said and discussed at the meeting. TWT appealed, and one of the grounds of appeal was that they argued that the restriction on variations to the contract and the subcontract were inconsistent with a finding that the parties had intended to be immediately bound by the agreement that was reached in February 2018. Their argument was essentially that the parties intended to reduce that to writing before it was binding on them, in accordance with their no oral modification clause. TWT didn't on appeal challenge His Honour's findings in relation to the effect of no oral modification clauses, which was consistent with the Australian position at that time and still is, that no oral modification clauses don't prevent parties from entering into a new contract to vary their earlier agreement. Because there was no challenge to His Honour's finding in that regard or to the earlier decisions on that topic, the Court of Appeal didn't need to consider the effect of no oral modification clauses in the Australian context, and it didn't do so. What it did do is it talked about the contextual importance of a no oral modification clause in an earlier written contract, and it did note the contrary view, as it called it, that had been reached overseas in the United Kingdom in light of the Rock Advertising decision. In considering the argument that TWT put in effect that the no oral modification clause was inconsistent with the parties entering into an immediately legally binding contract, the court looked at the factual findings that were made by His Honour Justice McDougall and ultimately found that those factual findings were consistent with the evidence, and there was no reason why those findings would be overturned solely on the basis of the no oral modification clause. The appeal was dismissed for that reason and a number of others, as there were other grounds of appeal, and Bundanoon kept their almost $4 million. The next decision, which came after the decision in Bundanoon, was the decision of White and Phillips. Now, in that decision, President Bell referred to the comments made by Justice Gleeson in the Bundanoon decision, and in particular, the comments with respect to no oral modification clauses. The case involved a written contract between Philips and an X-ray company, under which Philips was to provide services in relation to the servicing of CT equipment. The contract contained, obviously, a no oral modification clause, and the contract was guaranteed by the two directors, including Mr. White. The facts were that after the X-ray company had fallen heavily into arrears, Mr. White had attended a meeting with a representative of Philips. Mr. White said that at that meeting they had agreed to either terminate their earlier contract or to vary it such that he and the X-ray company were no longer liable for invoices which had not been paid. Mr. Damon, who was the representative of Philips, his version of that meeting was effectively that it was a discussion in relation to the addresses to which the invoices should be sent. And when Mr. White raised with him a concern in relation to the costs that he had been charged with respect to the servicing of the CT equipment, he said basically that our costs are as low as they can possibly go and we can't go any lower. Therefore, there was no agreement to vary the earlier contract or to terminate it. Judge Olsen in the District Court made factual findings in relation to that meeting and ultimately found in favour of Phillips' representative that there was no variation of the contract. Mr. White, who was the only one left by the time of the appeal proceedings, challenged the factual findings on appeal, and he said basically that his version of events should have been preferred. The Court of Appeal dismissed the appeal on the basis that the factual findings were sound and the judgment was maintained. Therefore, because of that finding, there was no need for the court to consider the effect of the no oral modification clauses. However, President Bell made some comments about them anyway, particularly in light of, I suspect, the recent decision in Rock Advertising. First, His Honour noted that because Mr. White was unsuccessful in his challenge to the factual findings, there was no need to consider the issue. He went on to say that no oral modification clauses are nevertheless relevant in considering whether parties intend to modify their earlier contract. He referred to them as providing important context when considering the parties' objective intentions. That's consistent with the current Australian position. But he then went on to make some comments in relation to the benefits of no oral modification clauses being effective. He commented that if they were effective, many disputes of the kind which arose in that decision could be avoided. He said, and I'll quote him because he says it much more eloquently than I could, one of the virtues of such clauses might be thought to be the avoidance of disputes of the very kind that arose in the present case, as to whether there had been a variation of the contract, and if so, what the terms of the variation were. Variations in writing leave no room for dispute as to what was actually agreed, subject to any ambiguity as to the agreed form of the written words. So the question then becomes whether there will be a reconsideration of the Australian position in relation to no oral modification clauses. The comments made by the Court of Appeal suggest that the Court of Appeal in New South Wales at least may be interested in at least discussing the topic, particularly where President Bell has commented on the benefits of a no oral modification clause being effective and avoiding disputes. However, as a number of decisions have pointed out, the position in Australia is well settled and it is consistent with High Court authority, and therefore, if it is going to be changed, it may be necessary for it to proceed to the High Court for a real change in law to be effective. The other alternative is that the Court of Appeal may wish to distinguish on the correct facts, distinguish a further decision if this topic is brought to their attention in a further case. But effectively, we don't know which way the court will go, though they do seem interested in discussing the topic. I will hand over to Ben to talk to you about the Rock Advertising decision.
Thank you, Ian and Ashley. As introduced, I'll be speaking on Rock Advertising and MWB Business Exchange Centres. This was a May 2018 decision of the United Kingdom Supreme Court, unanimously upholding an appeal from the United Kingdom Court of Appeal that had denied the effectiveness of a no oral modification clause. Now, Lord Sumption, with whom Lady Hale, Lord Wilson and Lord Lloyd Jones agreed, wrote the majority decision. And it is clear from the first paragraph of Lord Sumption's decision that the import was not lost on him. And I quote here, he says, "Modern litigation rarely raises truly fundamental issues in the law of contract. This appeal is exceptional. It raises two of them. The first is whether a contractual term prescribing that an agreement may not be amended save in writing signed on behalf of the parties is legally effective." Now, I pause there to note that the other issue that's not presently relevant was in respect of consideration, namely whether or not good consideration had passed for the variation in this case. So turning to the facts of Rock Advertising, briefly stated, MWB operated serviced offices in London. Rock Advertising entered into a license agreement with MWB to occupy offices for a year, and that agreement contained a no oral modification clause. Rock Advertising fell into arrears, and its director negotiated an oral agreement with a credit controller from MWB to reschedule the payments. Rock Advertising began to comply with that new agreement, making the rescheduled payments. The credit controller took the what was said to be the proposal to her boss for consideration, who rejected it. MWB demanded the full amount outstanding under the written agreement. However, MWB was not paid, and it proceeded to lock Rock Advertising out, to terminate and to sue for the arrears. Considering briefly the decisions below, at first instance, Judge Maloney QC found that the license agreement had been varied by an oral agreement with the credit controller, who had ostensible authority to vary the agreement. However, as it was not varied in writing in accordance with the no oral modification clause, it was ineffective. The Court of Appeal overturned the decision, finding that no oral modification clause was ineffective to limit the parties' subsequent bargaining power, and that the license agreement had been varied by the subsequent oral agreement, which also amounted to an agreement to dispense with the no oral modification clause. And can be seen that the decision of the UK Court of Appeal generally accords with the Australian position. Now, the Supreme Court unanimously allowed the subsequent appeal, and while it was a unanimous decision, Lord Briggs wrote a separate decision in which he reached the same result by a different and, with respect, a little hard to follow path. Now, there's a brief discussion and references for that in the paper, if you're interested. Turning to the arguments in Rock Advertising, Lord Sumption began by noting that in the United Kingdom at common law, there are no formal requirements for the validity of a simple contract. His Honour pointed to one former exception at common law, and then noted that the other exceptions to the principle of informality are all statutory, although none applied to the facts. In respect of the exception at common law, before the legislative change in 1960, a UK company could not bind itself otherwise than under seal. And now that was abrogated over time, but it was done away with finally in 1960. So the important point here is that there has been statutory abrogation of party autonomy in numerous contexts. In the United Kingdom, contexts include statute of frauds and certain consumer contracts. In the US, there's the United States Commercial Code, and internationally, there's the Unijoint Principles of International Commercial Contracts. Indeed, an authority often quoted for party autonomy is from the US, and it's a decision of Justice Cardozo in Beatty and Guggenheim Exploration, and the reference is in the paper. and that's a 1919 decision. However, party autonomy in the US was significantly curtailed with the introduction of the United States Commercial Code and its requirement for contracts above a certain value to be in writing, which captures contracts of variation. Although there is a carve-out for the sorts of circumstances where equity would intervene in the code. Lord Sumption proceeded by reciting the argument for autonomy, and this is the three-stage argument that is most often deployed in denying effect to notice of no oral modification clauses. First, a variation of existing contract is itself a contract. Second, that precisely because the common law imposes no requirements of form on the making of contracts, the parties may agree informally to dispense with an existing clause which imposes requirements of form. And third, the parties must be taken to have intended to do this by the mere act of agreeing a variation informally when the principal agreement required writing. Now, Lord Sumption then sought to turn the argument from autonomy on its head, and I'll read this quote. "I think that this is a fallacy. Party autonomy operates up to the point when the contract is made, but thereafter only to the extent that the contract allows. Nearly all contracts bind the parties to some course of action, and to that extent restrict their autonomy. The real offence against party autonomy is the suggestion that they cannot bind themselves as to the form of any variation, even if that is what they have agreed." So what's going on here? This is the conceptual dispute about which contract you want to recognise the parties' autonomy in respect of. The traditional view, as recognised in Australia and previously in the UK, says that it is the contract made later in time in respect of the autonomy of the parties should be recognised. Lord Sumption's view, which held sway in the UK Supreme Court, says that it is the original contract in respect of which autonomy of the parties should be recognised. Now, the traditional view is based on two related assumptions. The first is that the parties always know what they're doing, and second and related is that the later in time contract will better reflect the parties' intention because people change their minds. Lord Sumption's view denies both of those assumptions, and we'll see takes something of a legal realist approach to the question. So Lord Sumption turned to the practicalities and observed that there are at least three reasons for including a no oral modification clause. And the first is that it prevents attempts to undermine written agreements by informal means, a possibility which is open to abuse, and the example there given was in respect of raising defences to summary judgment. The second is in circumstances where oral discussions can easily give rise to misunderstanding and cross purposes, it avoids disputes not just about whether variation was intended, but also about its exact terms. Indeed, this is the very point highlighted by President Bell in White and Phillips. And third, no oral modification clauses afford a measure of formality in recording variations that make it easier for corporations to police internal rules restricting the authority to agree to them. Further points made by Lord Sumption, firstly that considering those practical realities, His Honour observed that the law of contract does not normally obstruct such legitimate intentions of business people, except for overriding reasons of public policy. Yet there is no mischief in no oral modification clauses. Indeed, defeating legitimate intentions is a strong point. It's not said that the parties cannot change their bargain, merely that they must formalise any such change in the way in which they initially agreed in writing. Secondly, Lord Sumption noted that the natural, or observed in his view, the natural inference from the parties' failure to observe the formal requirements is not that they intended to dispense with the no oral modification clause, but they overlooked it. If, on the other hand, they had it in mind, then they knowingly courted invalidity. And this is, I think, one of the key points from Rock Advertising, because it highlights the artificiality of an implied agreement to vary the no oral modification clause. And thirdly, Lord Sumption noted that there are sufficient safeguards for subsequent oral variations in the law of estoppel. However, that for estoppel to apply, there would need to be some words or conduct, more than the informal agreement itself, to represent that the variation was valid despite its informality. And this is a key point. Nothing said in ROC advertising or in the legislative abrogations of party autonomy referred to stands in the way of relief where one of the contracting parties has, by its words or other conduct, induced the other party to believe that the contract has been validly varied and or that the no oral modification clause will not be relied upon. Will not be relied upon. So in the result, Lord Sumption, with Lady Hale, Lords Wilson and Lloyd Jones, considered that the law should and does give effect to a contractual provision requiring specified formalities to be observed for a variation. And their honours found that the oral variation which Judge Maloney found to have been agreed was invalid for the reasons that he gave, namely the want of the writing and signatures prescribed. I'd like to turn to the context of building and construction contracts in particular. Often complex building and construction contracts are based on standard forms resulting from exhaustive deliberative processes. Indeed, the head contract in the Bundanoon Sandstone case was based on AS 4000, 1997. Now, it can be said that the arguments for requiring compliance with no oral modification clauses could be said to have greater force in this context. And that's to say that in circumstances where familiar contracts containing very detailed written procedures for proposing and approving variations or extensions are entered into by well-advised, sophisticated parties, the scope for oral modification surely shrinks, if not vanishes. And so much can be seen in how Australian courts use the existence of a no oral modification clause contextually when considering the question of whether or not the parties actually intended to vary their contract orally. Indeed, by not giving effect to formal requirements, such as in a no oral modification clause, undermines a central pillar of detailed building and construction contracts and opens up an avenue for abuse and spurious claims. Whereas giving effect to no oral modification clauses avoids disputes about whether a variation was intended and if so, what was actually agreed. And efficacy for no oral modification clauses accords most closely with the formality necessary to achieve changes in such complex contracts, often with numerous internal contributors and hierarchical approval processes. In conclusion, wherever one lands on the doctrinal debate about autonomy, it's submitted that permitting argument on and granting relief in reliance upon oral modification of complex building and construction contracts, at least, arguably frustrates the obvious commercial purposes of the parties. And perhaps the conceptual debate is insoluble at the end of the day. However, when one takes a realistic view of what the parties actually do and the practicalities of the matter, as in ROC advertising, it can be seen that the enforcement of no oral modification clauses best realises those commercial purposes and importantly saves court and other resources. Now, Ashley spoke about the possibility for judicial reconsideration in this area. Well, what about legislative intervention? We think it's unlikely, just there wouldn't be the interest, unfortunately. But it can be said that such legislative intervention could be achieved relatively easily. One way, in respect of building and construction contracts, would be for legislative force for no oral modification clauses included in contracts based on standard form building and construction contracts. Or alternatively, there could be a blanket legislative requirement for written modification of commercial contracts with an initial value above a certain limit. Both of those possibilities would be subject, of course, to equitable relief being available in appropriate circumstances. Thank you.
You can say that? That's all right. Thanks, Ben. Thank you, Ashley. It's fair to say that virtually every construction dispute in which the contractor claims variations, Lieb and Molloy is dragged out to justify the failure by the contractor to do the dance in a contractual sense. So a shift in the direction that the UK Supreme Court has taken will have a pretty dramatic effect on many of those claims. I'm going to throw the floor open for questions. Would anyone like to ask anything of either of our speakers? Yes?
Perhaps more a comment than a question.
Yeah.
But in terms of the policy debate, one side or the other, in relation to this, I guess from a personal point of view, I've always had sympathy for the idea of allowing oral modification, even in the context of such a clause, simply because it seems to reflect normal human behaviour and expectations, like the way most people, and I'm not talking about lawyers, but most people behave. They think that they can shake hands or do a deal without necessarily realising that they might have signed a contract 5 years ago which said something else. And it's interesting to note that in the paper you referred to the reasoning of Lord Sumption, in support of this approach, where he says, well, look, it's not necessarily that they intended to dispense with the requirements of the clause, but that they overlooked it. But it seems to me, well, if both parties overlooked it, then why is that a reason not to allow it? Isn't that a reason to allow it? Because if both parties genuinely forgot about the contract in the bottom drawer and intended to shake hands or do a deal in the boardroom, if they both overlooked it, then should it really be permissible to allow one party to say, oh yes, but there's a contract and here it is, boom, boom. I just wonder if you've got some views on that.
I'll go first, if that's right. I think in a lot of cases, equity would intervene in those genuine circumstances.
If you prove, but would you have to then put a fact in issue whether people had actually remembered the clause or not? I mean, would that be relevant?
Well, I think the starting point would be whether or not representations through words or conduct by the party seeking now to enforce the no oral modification clause, induced the other party to proceed on the assumption that they did have a binding agreement that didn't need to conform to the formalities of the no oral modification clause. So I think that equity would respond in a lot of the cases in which there would be genuine conduct of the parties inducing each other.
Well, I can understand that if that was perhaps one party knowing about the contract, but sort of going about in the negotiations on the basis that the other party had forgotten about it, but if they were really genuinely both, well, I really think this is a deal, and kind of acted on that basis.
So is
sort
it
of one party?
the comment that you're making essentially is where both parties proceed on the basis that they can vary the contract, is that a distinguishing fact from circumstances where one party is mistaken about the ability to vary the contract and proceeds?
Yes.
And I think, not knowing the decision as well as Ben and Ashley do, I suspect that probably doesn't matter in the way that the Supreme Court have approached it. If it were one party taking advantage of the failure of the other party to understand the contractual obligations, and that may have a different outcome. But where both parties, and this happens in Australia all the time, the whole of the construction industry, as I was saying to them earlier, is based on mates rates. You go to all this trouble and create a suite of documentation that has everything determined in writing, set out clearly, and then you put that in the bottom drawer and you proceed with the project as if the whole deal had been done on a handshake, without sort of using the contract as a means by which the parties can properly understand their rights and obligations in the project. Now, in those circumstances where it's put in the bottom drawer and parties go on and proceed as if they're dealing with each other on some other basis, and then come to an agreement about a change in the works, a change in the scopes, or change in something that's material, can one party then in those circumstances turn back to the contract and say, hold on, we've got a no oral modification clause, I'm not going to allow you to perform the contract in that way or change the contract in that way. But the sort of things that you're talking about, I suspect, would be dealt with by applying equitable principles estoppel, and you'd need to have a reliance, presumably depending on the nature of the estoppel pleaded, but you'd need to demonstrate there's some reliance on the conduct by the other party. But in circumstances, as you say, where both parties forgot that there was a contract, yeah, which happens, I suspect that that's the very situation that the Supreme Court in the UK were dealing with, and would come to the same view as they did. But you guys might have a different view about that.
The only thing that I would add is that some of the decisions don't relate necessarily to an express modification of the earlier agreement. So, for example, in some cases there was a procedure by which they could vary, for example, the amount that they would pay per square metre. And then they'd adopted a course of conduct over years by which they said, well, they submitted a new amount and then they agreed on it, they turned their minds to it and all those things. And so then later on, the party who had been paying more money than they realised they had to under the agreement because they hadn't complied with the variation clause, later said, well, no, we haven't complied with the variation clause, we're going to have to pay that smaller amount of money. And the courts in those situations did step in and say, well, that's not how it works because there's a course of conduct. So I think if you've got a course of conduct, then certainly in the Australian position, you would be protected by the fact that there was that ongoing conduct and that ongoing turning of your mind to the variation of the original contract.
Without reliance on the stock.
Yeah.
But even in the UK New World Order, you potentially have an estoppel by convention, though, wouldn't you?
You would.
But if that was a consideration, then the legislation you propose wouldn't work, would it? Because that wouldn't then take that into account.
Well, I was going to take up that point, actually, because we've virtually got that in the Home Building Act, but it doesn't seem to do anything to avoid the problem, because Labour lawyers still pulled out and relied on by contractors in residential building disputes. And the fact that the Act and the contract require writing is somehow avoided, where a party says, well, I know they require writing, but we had a different agreement and we agreed inferentially or otherwise to not impose that strict formal requirement. So the legislation, if it were to be brought in, would have to be pretty clear and far-reaching and go beyond what the Home Building Act does now, would it not?
I certainly think equity could respond in circumstances where both parties have forgotten that they have any contract, providing that they make the appropriate representations that they both are saying, we don't have, before this new deal, we don't have a contract. As it would respond where one has sort of kept the contract in their back pocket and has allowed the other party to progress on a mistaken basis.
The problem with the Australian approach, I suppose, compared to the English approach, is that very situation and the need to distinguish between circumstances where one party knew and the other party didn't and was allowed to proceed under a misunderstanding, and then circumstances where both parties proceeded incorrectly in terms of the contract. That itself throws up a factual dispute that enforcing a no oral modification clause avoids, and I think that was Lord Sumption's key point. You don't have to get into that sort of debate about whether what was said, what it meant, did the other side understand it in the way that you say you understood it at the time, and all those sorts of issues, which are very difficult to resolve by a court often years after the event, based on parties' recollections of what was said in one of thousands of meetings during the course of a project. And this just avoids that problem. But as I said, we virtually have the legislative prohibition against that, but it's not always the answer in any event. Yes, got another one?
If the law in New South Wales was to head in the direction, or if there was to be judicial reconsideration, was headed in the direction of the UK, do you think that sort of misleading and deceptive conduct would come into the equation as well? In other words, whether or not we've reached an agreement, but I've certainly set an expectation up in my mind that I'll carry out this agreement in a particular way, and for example, you've got enacted on that and entered into a subcontract or something like that. Do you think that could potentially come to the rescue of a person arguing that the clause was effective if the law moved in the direction to perhaps be less supportive of a non-clause?
I'm not sure if the microphones pick these questions up, but the question is whether a claim for misleading deceptive conduct would be defeated by a no oral modification clause in circumstances where there was conduct which otherwise would give relief under the Act. Do you guys want to express a view about that? I know I have one.
You can go first.
I think undoubtedly Section 18 would trump any state legislation that tried to impose on parties an obligation to comply with those sorts of agreements. And I'm assuming it's state legislation. I doubt the federal government would have any interest, if it had any power, to get into that field.
Yeah, I'm thinking less about the sort of federal-state issue, but more the, not if the legislation came in, but more if the judicial view evolved.
Yeah.
A view that was a bit closer to the UK.
I think for the same reasons as Lord Sumption said, that equity prevails, then a Section 18 claim would prevail, even if you didn't have that Section 109 type debate. You'd still have an ability to claim for relief under the Act that were given because of the ACL.
There could be a complexity if the parties themselves weren't aware of the fact that it was misleading. So, for example, if the parties had forgotten that they had a no oral modification clause.
Well, that might go to whether or not there has been conduct that's misleading and deceptive, though.
Exactly.
And if you don't get over that threshold, then you don't worry about it.
So, only to point out that
Yeah.
potential.
I certainly think you'd see, if the New South Wales Court of Appeal moves in the direction of rock advertising, I certainly think you'd see people leaning more heavily on misleading and deceptive conduct to try and make up the difference.
Yeah.
But of course, it's highly unlikely that you would get the sort of relief that you want at the end of the day, which is the contract being enforced or not enforced in the way in which you're arguing. But it would obviously sound like loss of damage.
Thank you.
Any other questions? I have one. In paragraph 21, you refer to the entire agreement clauses and the analogy that was drawn. Is that separate? Is that dealt with differently by His Lordship to the no oral modification clauses? You say you drew an analogy. How did he distinguish them?
Well, he attempted to draw an analogy to support his view in respect of no oral modification clauses. So, after setting out the arguments that we've discussed this evening in support of his view on no oral modification clauses, he says, and the same that really applies in respect of entire agreement clauses. And he goes through some pretty detailed analysis as to why he thinks that the entire agreement clause works in an analogous way. The reason why I think it's not so effective is because obviously an entire agreement clause is backward looking. It seeks to make certain that all of the possible prior representations, collateral warranties, all those sorts of things that were discussed could be digged out of emails after the fact before a contract was executed. It seeks to put all of those to one side and say this is the bargain of the parties. Whereas the no oral modification clause is obviously dealing with subsequent agreements, albeit oral. So Lord Justice Briggs, I think, pays pretty short shrift to that analogy, and I think he's right on that.
Yeah.
He's not right, however, when he comes to discussing no oral modification clauses. It's quite confusing. He seems to suggest that the position should be that they can be, that the parties can orally depart from their no oral modification clause, providing that they actually consider at the time of their new contract that they are also varying the no oral modification clause. And quite simply, I don't know if anyone's ever done that and they've orally varied a contract. Oh, and by the way, we're also going to orally vary the no oral modification clause.
Well, I raise it because it's often alleged in circumstances where parties rely on a entire agreement clause that, as a matter of fact, the prior representation predated the contract, and in fact, had they not been induced to enter into the contract, they wouldn't have entered into the contract with the entire agreement clause and so on. And that sort of factual scenario, I suppose, would then feed in potentially to an estoppel argument in the context of the no oral modification clauses. But so they're a little bit different. And when you refer to the analogy that was drawn, it was I can see that there would be some help in comparing, but not entirely an answer to the question. And the other reason I thought that might be worthwhile looking at is that they're more common, those cases, than
Yes.
oral modification clauses, and if there's to be something dealt with by the High Court, it's more likely that that could get up as a vehicle, simply because there's more of them, I think, than an oral modification dispute. But due to the slight differences, perhaps it would be regarded as an inappropriate vehicle in any event.
I do think the analogy is quite helpful up until the point when you must consider that autonomy is forward-looking in the oral modification clause context.
Yeah, okay. Yes?
Just one more, it's sort of tied to that. Have any of the courts given any consideration to the distinction between quite literally an oral conversation versus, for example, an email chain, where the contract may say any amendment must be in writing signed by the parties, and in the end it's in writing, but it's just an email exchange, as opposed to an oral conversation? Do you think that they were treated in the same way, or would there be a different approach?
I think the case I was referring to earlier, where there was correspondence between the parties as to how they were going to deal with the new price for their product, and there was correspondence, and even though it didn't comply with how they were supposed to do it under the contract, they found that there was a new agreement, there was a variation pursuant to that conduct. So I suspect it will be dealt with in the same way, in the sense of the Australian position, that is that you wouldn't be restricted from varying your contract either by email or by orally or in any other way, or by conduct. So,
Is it the same for an agreement and a deed? Because there are those old rules about, I've looked at it for a while, but a deed arguably should have been amended by a deed and things like that. Is there a distinction drawn in case law between agreements and deeds at all?
I don't recall reading a case on deeds.
The deed would have to be amended by deed.
That's what I would have
Yes.
thought.
Yeah. Look,
Yeah.
I think if you had a email in respect of where there's a subsequent agreement to vary the earlier agreement, it's highly likely that would be considered in writing and signed by the parties, such that you may not get to the question of whether or not the no oral modification clause applies. But obviously that's also some pretty significant, depending on the chain of correspondence and what's actually been agreed and how it's got there, may also play into the equitable.
I mean, two comments in relation to your comment. I mean, one, I think on signatures and emails, the Electronic Transactions Act might apply to make that less important in terms of dealing with an email.
It's
signature,
definitely
like
signed.
as
It's
a
definitely
signature.
signed.
If it actually is by exchange of emails, that's probably a moot point. And in terms of varying a deed by a deed, correct me if I'm wrong, you could still vary a deed by agreement if it takes effect as an agreement.
Yep.
Rather than, so,
absolutely.
But in the case of the emails, it might just come down to evidence of what was exchanged and what it meant. But it's more likely that the vice that this is trying to overcome is cured, because it's not a case of relying on who said what in a meeting. You've got a document in an email that sets out precisely what the parties said in their exchange. So that's one of the problems that's overcome. And then you've only got formal requirements under the contract, and I would have thought a court now would be less likely to require some strict formality in circumstances where there's no dispute about what the communication said. There might be a dispute about what it means, but not what was said.
I think that's right. And the oral modification clause doesn't even arise in those circumstances, and the court just proceeds on the basis that
Treats it as writing.
you've had your written variation. It's just a question of what you actually agreed when you did it.
Anyone else like to ask a question or make a comment? Okay.